Bismillahirrahmanirrahim. My dear students, we were discussing the chapter of administration of justice, and in this chapter, we will discuss what are the kinds of administration of justice: civil administration of justice and criminal administration of justice. Civil administration of justice, as we were discussing, that it enforces the rights of individuals, those rights which are arisen out of the contracts, agreements, family matters, office matters, and property matters. And these rights are basically enforceable between the parties inter se. Those people who are involved in the transaction, this civil law will regulate their affairs, their rights, and their duties. By and large, contracts, agreements are uh, uh, you know come into the domain of the civil law, broadly speaking, I am saying. And the purpose of the civil administration of justice is to enforce the private wrongs, or to enforce the private rights. Again, I will repeat that private rights are those rights which are available to few individuals who are in some way or other the parties to the transaction. The rest of the society has nothing to do with it. Whereas the criminal administration of justice regulates the public wrongs and public rights. Public rights are those rights in which state becomes a party, and in which the interest of the state is involved. And the purpose of the criminal administration of justice is to punish the wrongdoer either by way of imprisonment or by way of fine or death. So this is the two kinds of criminal administration of justice and civil administration of justice. Procedure of both is quite different. The regulation of the civil law starts from the plaint. Plaint is the first step to put in motion the civil mechanism. What is plaint? Plaint is basically an application which is filed by the plaintiff to indicate the to indicate his grievance, to indicate his cause of action, to indicate his which right has been violated. Plaint is basically the narration of the facts. There is no law point is present in the contents of the plaint, only the facts. After the filing of plaint, the court will summon the other person against whom the complaint is filed. So the second step of the civil procedure is written statement. Written statement is the para-wise reply of the defendant against the plaint which has been filed by him by which has been filed by the plaintiff against him. In the written statement, the defendant will reply para by para, and either he negate the allegations made in the plaint or he accepts the allegation made in the plaint. If he negates all those allegations made in the plaint, then there come there comes the third step of civil procedure, which is called issues. So issues are points of differences which have been created between the plaint and written statement. If there are no point of differences, then the case will be disposed of. No need to go further. If defendant admits that he has admitted all the allegations made in the plaint, then the case is closed. Will be, he will be directed by the court to do such and such thing as prayed by the plaintiff. But if he objected all those allegations which have been alleged against him by the plaintiff, then there come issues. Issues, as I have said, this is the third step. Issues are basically the points of differences, the conflicting points in which one party claims something, another party denies something, in which one party is asserting a fact, another party is denying that very fact. So whenever issues arise, it has to be resolved. This has to be, this has to be addressed. Which party is saying correct and which party is telling the lie, which party is speaking the truth. It has to be resolved. By what way points of differences are resolved? Evidence. Fourth point of the steps of civil procedure is the evidence. Now the question is this: what is evidence? You must have studied it in Evidence Act or Kanun Shahadat order in detail. That what is evidence? To tell you evidence, I will say that evidence. First, let me put a very simple definition for you so that you can understand the concept about the evidence. Evidence is a material on the basis of which facts are proved or disproved. Evidence is a material on the basis of which facts are proved or disproved. Right? By material, I mean that evidence is maybe of hundreds of kinds. There are more than 100 kinds of evidence. Evidence is direct evidence, indirect evidence, primary evidence, secondary evidence, hearsay evidence, circumstantial evidence, expert evidence, direct evidence, real evidence, personal evidence. You can say uh, manifold kinds of evidences. Sometimes the object which has been used while the commission of the crime is also called the evidence. Sometimes the attendance register which we fill for you, this is also a kind of evidence. Sometimes uh, mm, the piece of stone, it may also be termed as evidence. So whatever is being presented in the court of law to substantiate one's stance, to substantiate one's narrative, can be called evidence. So, but the concept of evidence, which I believe is more philosophical, as you know that the Evidence Act is just a philosophy. It's a reasoning, a rationality, or the it hit the reason of the judge or the lawyer. So I will say that, having said this, that evidence is the material on the basis of which facts are proved or disproved. Let me go a bit further. That evidence is basically something by which you can dispel the obvious. Dispel the obvious. To dispel the obvious. Dispel means to reveal something. किसी चीज़ को आश्कार करना, किसी चीज़ को मंजर आम पे लेके आना, किसी चीज़ को आप लोगों को लोगों को किसी चीज़ का इल्म या नॉलेज नहीं है, अदराक नहीं, आप वो चीज़ जो ऑलरेडी है, एग्जिस्टेंस में है, उसको लोगों के सामने लेके आके खड़ा करता है। दिस इज़ कॉल्ड टू डिस्पेल। वेर एज ऑब्वियस मीन्स, ऑब्वियस को उर्दू में कहते हैं खुला, ऐसी चीज़ जो वाजिया हो। लीगली स्पीकिंग, द टर्म ऑब्वियस मीन्स something which is already there, something which has occurred, something which is reality, something which has been caused, something which has been inflicted, something which is there all the time. We are not seeing it, we are not, we are not grasping it, but it is there. In Let me give you a very easy example. Sometimes if you watch movies, then police are investigation. Then police investigate something, and there is a very famous dialogue which they usually say that कि यार चीज़ें मेरे सामने हैं पर मुझे नज़र नहीं आ रही। इसका मतलब ये है कि जो चीज़ वकूफ़ पज़ीर हो चुकी हो लेकिन आपको उसका सुराग ना मिल रहा हो, आपकी सेंसेस में वो चीज़ ना आ रही हो लेकिन वो चीज़ है, उसको कहते हैं ऑब्वियस। फॉर एग्जांपल, अगर मैं आपसे कहूँ कि पीछे इस दीवार के पीछे एक नदी है, नदी बह रही है, देयर इज अ स्ट्रीम बिहाइंड दिस वॉल, एंड यू विल से डेफिनेटली सर वी डोंट नो। आई वुड से यस यू आर राइट, अंडरस्टूड, you don't know because there is a wall between you and the stream, or there is a curtain. Suppose there is no wall, there is a curtain between you and the stream. What if I remove that curtain? What if I remove that curtain? Then you will see it, yes sir, there is a stream. So my removing that very curtain in order to make you see the that very stream is called the evidence. Now relate it in the court of law. Judge is a blind. He doesn't know. He doesn't know whether you are speaking the truth, which party is lying, which party is speaking the truth. A lawyer is supposed to remove that curtain, remove that barrier between him and the fact by way of evidence. The means, the tools which he will use in order to make it understood to the judge, those tools, those means, those methods will be called evidence. I hope you will be in a better position to express it, to define it. Now, evidence, after the evidence, the fifth step of the civil procedure is arguments of the lawyers. Argument of the lawyers is basically further bifurcated into three modes. There are three modes in which a lawyer can argue. Number one is the examination in chief. Number two is the cross examination. Number three, re examination. So, what is examination in chief? Examination in chief is basically the questioning of a lawyer to his own client. Let me brief it. A client who hires a very smart lawyer, that lawyer must establish his case in front of the judge by telling him the exact situation. What he wants to prove, he has to say it before the judge through his client. So, in the court, he will call his client and ask him, tell me, what are you saying? What is your grievance? He will say that there was a man, he's sitting right there, the defendant. He violated the terms and condition of the agreement which has been duly signed by him and me. This is the agreement. The lawyer will say, is it true that these two witnesses are there when you have signed this agreement with the defendant? He will say, yes, these two are the witnesses which were present during the formation of the agreement or formation of the contract. Okay. So, can you name them? So, this is the another question of the lawyer to his client. Yes, he will say, Mr. A and Mr. B. Can you convince them to come into the court of law and give testimony in your favor? You will say, yes. So, let's bring them. So, now the examination in chief is in progress. So, the lawyer is calling those witnesses who are in his favor, and their witnesses will give their testimony in favor of his client. Now, the judge is watching, observing all this. So, he is building his case, he is building his case. The plaintiff side is building his case, is establishing his case in front of the judge, in front of the jury, as the case may be. So, the purpose of the examination in chief to bring out the cause of action, bring out the actual picture, bring out the demand, the request, the prayer of the client in whatever way before the court of law. So, this is the first step of the arguments of the lawyer, examination in chief. Now, cross examination. Cross examination is basically the examination of the opposite party to the opposite witnesses or opposite uh, party. If the in cross examination, if the plaintiff is asking a question, he must be asking the question to the defendant, and if the defendant is asking the question, he must be asking to the plaintiff. So, cross examination is the most famous, most dramatic, and most critical stage of the trial. First, let me define what is cross examination itself. Cross examination is the best available engine ever discovered for the discovery of the truth. Cross examination is the best available engine ever invented for the discovery of the truth. Now, all those arguments, all those bases which have been established in the examination in chief will be shattered, will be impeached, will be discredited, will be shattered in the cross examination. The lawyer of opposite side will tarnish the establishment of case in every which way. First of all, he will create doubts in the statements of the plaintiff in his plaint and in the examination chief. He will create uncertainties. He will create he will create discrepancies between his statement. Now, in first statement, he was saying something else. In second statement, he was saying something else. So there is a discredit involved in the testimony or in the narrative of the plaintiff. So whatever he has said, it will be meaningless. If and the judge is observing all the time. Judge is there all the time. He's observing. He's listening. And you all know that a good judge, is a judge who is a very good listener. He is not supposed to speak during the trial. His judgments and orders must speak. He himself is not supposed to say anything during the hearing. So, you know, so purpose of the cross examination is to discredit all those arguments which have been made in the examination in chief. Let me conclude it here. Now, the third stage of the arguments is the re-examination. In re-examination, the party who has conducted examination in chief will again conduct the re-examination. The purpose of the re-examination is this: all those discrepancies, doubts, uncertainties, ambiguities which have been created by the opposite counsel, it will be removed in the re-examination. So examination in chief will also be called by a lawyer to his own client. Similarly, re-examination will also be conducted by a lawyer to his own client. There is an opposite party involved. So in re-examination, the counsel, the lawyer will try to remove all those clouds, all those mists, all those uncertainties, and again try to establish his case. So the arguments of the lawyers are threefold, and this is the gist of those arguments. Now, in these three stages, evidences will be produced, witnesses will be produced, expert opinion will be presented if it is required. So, everything will be presented to substantiate the narrative of the other party. Now, after this, after the arguments, there comes a judgment. Judgment is basically the conclusive decision of the court. In judgment, the judge narrate, compile each and every day's arguments, each and every day's discussion during the trial. Everything which has been discussed will be compiled in the judgment, whether sometimes ratio decidendi become the part of the judgment, sometimes obiter dictas also become the part of the judgment. So each and everything, the trial, suppose civil trials uh, may go on and on for years. So in the judgment, everything will be compiled. So the judgment is basically the comprehensive decision of the court. After the judgment, there comes a decree. 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 Decree is basically the order of the court. In judgment, the small para in which the judge directs the plaintiff or defendant to do that very thing which has been prayed by the party who has won the case. Do that very thing is called the decree. उर्दू में डिक्री को हुक्म कहते हैं। फैसले का वो हिस्सा जिसके ऊपर अमल दरामद होना होता है वो डिक्री कहलाता है। सिंपल। Now, the last stage of the civil trial or civil administration of justice is execution. Execution means to implement, to materialize, to make happen the decree. Sometimes judgment has been made and decree has also been issued, but it will not be executed for certain procedural complexities. So unless and until decree is not executed, it is meaningless. It is, you know, it is futile. So decree is decree when it is executed. Unless it is not executed, it is just a piece of paper and nothing more. So the execution is the final step of the civil procedure. And suppose uh, the case was filed by the plaintiff that his land was wrongfully acquired by the defendant, and the decree was made that yes, the case is genuine and the land was wrongfully possessed or acquired by the defendant. So defendant is directed to vacate the land, and this has been mentioned in the decree, but the defendant does not vacate the land. So the court will send his bailiff, and bailiff will go and physically dispossess the defendant from the possession of the land. And when once he removed him from the possession of the land and the plaintiff enters into his premises, then we will say that the decree has been executed. So my dear students, these are the steps of the civil procedure or civil administration of justice. Now when the execution is made, what has been done? The right of the plaintiff has been enforced. So the object of the civil administration of justice is this: to enforce the right of the individual. His right is enforced in civil administration of justice. So this is the paramount object of the civil administration of justice, to enforce the rights of the aggrieved person. Shortly we will discuss the criminal administration of justice, inshallah.